The third case for the docket on Monday, December 13th, 2021, is Appeal Number 122078, Vicky Schmidt, Kansas Insurance Commissioner versus Trademark, Inc., also versus Doroteo, Ballin, and Ballin Company, LLC, Subject County, briefs both sides. We are ready to proceed, Your Honor.
Thank you, Mr. Shima. Counsel, if you would please come to the podium to enter your appearances, I would appreciate that. And then we'll let you come back to begin your argument.
Thank you. May it please the court, I'm Bill Townsley. I represent Trademark, Inc., which is the defendant, third-party plaintiff, appellant, and cross-appellee. Thanks.
Thank you.
Please the court, I'm John Nodgard, and I represent Vicky Schmidt, the Insurance Commissioner for the state of Kansas, in her capacity as the administrator of the Workers' Compensation Fund, the appellee in this matter.
Thank you, Mr. Nodgard. Mr. Townsley?
May it please the court and counsel, again, I'm Bill Townsley. I represent Trademark, Inc. Your Madam Chief Justice, I'd request 3 minutes of rebuttal time.
3 minutes is granted. Thank you, Mr. Townsley.
Thank you. This case comes to the court on petition for review from the Court of Appeals. It's an interesting case regarding the statutory interpretation of a subrogation issue in a workers' compensation case. Trademark Company is a family-owned home building company in Wichita. They are insured for workers' compensation. In the course of one project, they hired a subcontractor, Doroteo Ballin, or the Ballin Company, LLC, as a subcontractor. Despite that Mr. Ballin signed agreements with Trademark to ensure that there were no issues with liability for workers' compensation, in fact, on December 23, 2016, Mr. Ballin's employee, Juan Medina, fell from a ladder and suffered injuries. He subsequently brought a claim against Ballin, but Ballin was uninsured. As he is allowed to do, Mr. Ballin then selected through his attorney to proceed against the Workers' Compensation Fund. The fund attempted to bring Trademark into the action, but there's no procedural method for doing so. The case was completed in workers' compensation, and the Workers' Compensation Fund asserted a claim against Trademark in district court. The case is postured as a legal issue regarding statutory interpretation. Summary judgment motions were filed by both parties. The district court granted summary judgment for fund with respect to liability against Trademark and for Trademark with respect to the attorney fee claim asserted by the fund. The Court of Appeals affirmed both decisions, and in both the district court and the Court of Appeals, the decisions were based upon dicta from an old Supreme Court case called the Workers' Compensation Fund versus Silicone Distributing. The issue on appeal is whether under 44-532A, the fund becomes liable for, well, under that statute, the fund does become liable for an award if the employer is insolvent, uninsured, or unlocatable. The fund is then granted a cause of action against the uninsured, insolvent employer. The question here is whether 44-532A also grants the fund a cause of action against the principal that's not uninsured and not insolvent when there is no statutory language to provide for that claim. This is a pure question of law, and the answer to the question is no. The Court of Appeals erred here for two reasons. One is the plain and unambiguous language of 44-532. It does not grant a cause of action against a principal. Irrespective of that, if the court was still to adopt the language from the Silicone case, which is dicta, the result would still be the same when interpreting the statute. We turn first to 44-532A, and the plain language of that statute is significant here. It says if an employer has no insurance, and if an employer is financially unable to pay, then the Workers' Compensation Fund will be brought into the case. Sub B allows the Commissioner of Insurance to bring a cause of action against that employer for recovery of any amounts paid. Here, that's about $17,000. There's an additional claim for cost as well. fundamental rule of statutory interpretation, which I don't need to repeat to this court, is that the intent of the legislature governs. If that intent can be ascertained, we look first at the words that are used. And again, if the statute is plain language, unambiguous, the courts are not free to speculate and cannot read into the statute language which is not readily found there. Here in this case, we've got Trademark as a general contractor or principal. Ballin was a subcontractor. Medina was the employee of the subcontractor. The statute allowed Mr. Medina to choose his remedy, and here he chose to proceed against the subcontractor. Subcontractor is insolvent, uninsured, so the Workers' Compensation Fund steps in and handles the case.
We have these new mics, we have to be careful of that. Under your interpretation of the statute, could the injured worker have brought Trademark in?
Absolutely. And again, I think that's the injured worker has a choice under 44503 to make a decision whether to pursue a claim against a principal or against a subcontractor.
And so if we buy that interpretation, we're turning over control to the injured worker whether the fund can be reimbursed for the amount that it pays for the insolvent.
Effectively, that's right, or returning that over to that injured worker's attorney, and that was the case here. His counsel chose to proceed against the fund for whatever reason. And again, it's an appealing argument to say that, gee, if he has the choice of alternative choices or alternative remedies, why wouldn't 532A apply? Again, the language doesn't support that. And policy doesn't either.
Counsel, doesn't your argument presume, though, that the word employer is unambiguous?
Well, I think that's a twofold argument. Yes, we believe it is unambiguous, and if you followed 503 and substituted principal for employer, then it renders the statute nonsensical as it pertains to inserting principal for employer in both sub A and sub B.
But how do you deal with prior case law from this court that has found the word employer to be ambiguous and also has defined the immediate employer, a statutory employer, and even declared that the contractor and subcontractor are dual employers? How do you deal with that case law?
Well, and again, I think we look at the plain language here, and I don't know that the term employer as it pertains to 44532A is ambiguous. I would probably disagree with that assessment. And here, if we look at the underlying policy of what the Workers' Compensation Fund did, and again, the only case on point here, the only case cited for 44532A ever is the silicone distributing case. And that wasn't a case on point here. That was a case that was dealing with exhaustion of remedies as claimed by the Workers' Compensation Fund. And so in passing, that court said, you have a remedy against either subcontractor or principal under 44532A. And it was a reference in passing, but that was controlling for both the district court, and you saw it in the Court of Appeals opinion that they were bound to follow that precedent. Here, that's different, and this court is different than the court 30 years ago that issued the decision in silicone distributing. And significantly, the purpose of the fund has changed too. Back then, there have been two legislative changes to the Workers' Compensation Act in 1993 and 2011. Both followed silicone. At the time of silicone, historically, the purpose of the fund was to encourage hiring handicapped workers. The primary purpose for the fund was to allow an employer to submit a notice of hiring an employee with a pre-existing condition, and then if there was a workers' compensation claim, the fund would pay for that. The ADA changed all that, and the things that the fund provided back then became a matter of law. So now we look at the clear purpose of 44-532, and that's to give fund a remedy against employer that has violated Kansas law by failing to have its insurance. But the policy, in fact, is the fund is an insurer of uninsured insolvent employers. That's what it is today. And contrary to some recent Court of Appeals opinions, the fund is not a burden of taxpayers. Insurance companies fund the workers' compensation fund. So the fund has a remedy against the uninsured employer who has caused a problem because they didn't have insurance or they're insolvent. You've got an injured worker the fund is paid for. The fund has a remedy back against that employer, just as would occur if this played out with Trademark. But again, here we have Trademark that did nothing wrong and did everything right, in fact. And they are a principal or a general contractor. But under our interpretation of 44-532A, those policies are still forwarded by the fund incurring the liability and having the same remedies for relief that Trademark would have.
Going to look at policy, can't you also say that about the taxpayers of the state of Kansas? They didn't do anything wrong, and that's who funds the fund.
And you're wrong, and I'm sorry. I think
Oh,
that.
I'm sorry, the insurance companies.
Right,
are
insurance
assessed.
carriers. And so it's a distribution of that liability that then flows to every insurance carrier that does business in the state of Kansas. It's not a liability of the taxpayers. And so this result, again, it will spread the liability between every insurance carrier as a matter of business. It's an issue they deal with. That's what insurance companies do.
But they're also innocent too, correct?
Well, I think in doing business in Kansas, I don't know that you look in terms of innocence or guilt or, they may not be liable, but that's a cost of doing business is funding the workers' compensation fund. And there are other issues that the fund deals with too, whether it's employees that, there are other issues the fund deals with and other sources of income for the fund. But again, primarily it's from insurance carriers. It's a cost of doing business. Again, we believe that it's the policies of the Kansas Workers' Compensation Act are furthered by our interpretation of 44-532A, which again,
Doesn't that interpretation essentially read 44-503 out of the Workers' Compensation Act?
I don't think so. And again, you're looking at the choice of remedies against subcontractor or principal. As it pertains to the principal, that may be correct, but again, the policy then is here's a principal that's done everything
Why
right.
is 503 in there? I mean, the legislature clearly contemplated imposing liability on a general contractor who subs out work to uninsured subcontractors. So when you claim that you're wholly innocent in this matter, I think there's an argument at least that it's against public policy for general contractors to sub out work to uninsured subs.
Well, I'd agree with that.
And isn't that what 503 says? It says, look, you as a general really should be the one that's liable if you sub out work to an uninsured sub.
Right, and I see I'm out of time, may I respond? Again, Trademark did everything it could to ensure that it had subcontractors that complied with the law. They had a requirement that you had insurance, and even further, they had a requirement of not having employees, which fits within the statutory construct. So the point is, the 44-503, in the event that someone is uninsured, that's going to play into effect. Again, against the principle, though, this sharing, having the fund incur that liability is not particularly offensive from my perspective. Again, for my client who did everything right, but was unfortunately hired a subcontractor.
The law has to impose the burden of the real wrongdoer here, which is the sub who did not have insurance.
Right.
The law has to impose that burden somewhere else. And
Right.
so I guess as a policy question, you could ask, which actor is in the best position to prevent this harm from occurring. And it seems to me the legislature makes a reasonable policy choice to say, well, the general contractor is in the best position, so that general ought to ultimately bear the liability. Now, the question is whether or not the statutes actually effectuate that policy choice.
True.
But it seems to me that is the policy choice. Would you disagree with that?
No, and that's a policy choice. I think equally likely is that the fund incurs that liability for all insurance carriers. And again, particularly in this case where Trademark did nothing wrong. They unfortunately had a subcontractor who lost their insurance or didn't have insurance after the fact. But again, I think I can live just as well with the fund having liability under 44503 as it pertains to principals. Clearly, when a 44503 is directed to a subcontractor, they have the same remedies. They have the remedy to pursue that subcontractor, just as they would assume that the general would if the general is liable. So, again, I'm out of time. I'd like to just mention the cross appeal, and my only point there is that I believe our position is the Court of Appeals got that right, and that should be affirmed, just to deal with that in the opening segment.
Guard?
Please, the court, from the questions you've already asked, I think the court has a grasp on what the issues here are in this case. Appellant is attempting to have the court look at 44532A and find that that word employer is not ambiguous and only pertains to the immediate employer. There's nothing in the workers' compensation statutes that really defines an employer as being a general employer, an immediate employer, or a statutory employer. There's a general definition under 44508 as to what an employer is. If, as the Silicone case and that court and the Court of Appeals adopted that, saying that the Supreme Court at that time found that that statute was somewhat ambiguous and therefore had to be construed in accordance with the entire Workers' Compensation Act. And that's, there's a long line of cases, and this court knows all that, that when you're construing a statute, you're required to look at the entire act and try to bring the statutory scheme into some type of harmony and consistent with the legislative intent. A little bit of history on this issue is that under 44503, which was enacted in 1927, that made the general contractor and any subcontractor duly liable for an injured employee. What happened over time, and in 1974, the legislature addressed the problem where you don't have a general contractor. And I've been representing the fund for a long time, and I can tell this court probably 90% of the cases I get involve an uninsured employer who is not a subcontractor. So in those cases, the fund is impled, pays whatever the court orders, and then seeks some type of recovery against that employer. But when there's a subcontractor and a general contractor, or what we call statutory employer under 44503, they're both liable for the injuries and the compensation due to the claimant. And as Mr. Townsley indicated in answer to one of the questions, the claimant's attorney has the option of either pursuing the immediate employer or the statutory employer.
I have a quick question about that. If in this case we were to adopt what I understand to be the argument of your opposing counsel, that that the language in Silicone should be, we should reject that earlier language, would we also have to reject the holding of Silicone, which basically says, as I understand it, that an injured worker does not have to exhaust his or her remedies against the principal before applying for relief from the fund? I mean, don't those two go together in the Silicone case?
Well, the Silicone case was an administrative appeal, but that decision was correct, as I read the statute, and that the claimant does not have to pursue both.
Right, that was the principal holding of the case, is
That's
that the
correct.
claimant doesn't have to go after the principal first. The claimant can go straight at the fund.
Well, he goes straight against the employer.
But if the employer is
Then
insolvent,
then they implead the fund.
okay, but the language that is important for this case follows closely on that holding, and the court basically said, we're comfortable saying this because the fund always has a cause of action back against the principal.
That is our interpretation.
And my
of the-
question is, if we reject that, call it dicta or call it a rule from Silicone, does that necessarily mean we also have to reject the central holding of Silicone?
No. The claimant wouldn't have to go against both parties. He can choose one or the other.
So you would be comfortable with an outcome that says the claimant can go after the fund without going after the principal, but then the fund has no recourse against the principal?
No, I'm not satisfied with that determination.
Well, that's why I'm trying to get my hands or mind around what we do with the holding in the Silicone case. And I'm just asking, it seems to me from your perspective, it might be an all or nothing matter.
Silicone simply said that the claimant, the injured worker, does not have to pursue both the immediate employer and the principal. He can pursue either one. And he doesn't, and so that holding is still good. But when you look at when the fund is impled and the claimant has pursued the immediate employer, such as this case, then you have to look to 44503 and substitute principal for the term employer, giving the fund the right to go back and seek recourse against the principal, who, under 44503, the general contractor is ultimately responsible for all his subs. If you adopt the appellant's position and say that the fund is without recourse against the general contractor, then in essence, the general contractor receives immunity for having violated his obligation under the statute, which is to make sure that his subcontractors are all insured under the workers' compensation laws.
Counsel, can you help me process how this plays out down the road? So when the fund subrogates against the principal, what defenses are available at that juncture to the principal? Is there any claim preclusion? Are they prejudiced at that juncture in terms of they're no longer able to stand in the shoes of the direct employer? Or how does that play out down the road under your construction?
Going back to the case law, the principal and the employer are dual employers, and they're both responsible for the injuries to a worker. If the fund pursues the principal, and as we did in this case, and gets a judgment, the principal, by statute, has recourse to go back against his subcontractor. The individual who he should have insured had insurance in accordance with 44503.
But the principal's not in a position to contest the award at that juncture. They were never brought into the proceedings when the benefits were established to begin with?
That's correct. And I attempted to implead the principal in this case and put them on notice. There is no statutory authority for the fund to implead a principal. And the principal came into the administrative proceedings and raised that issue, and the administrative law judge found that they could not be made a party because there was no statutory authority to do so. But they were on notice, and they could have voluntarily come in and protected their interest, knowing down the line that under 44-532A, the fund in all likelihood was going to come after them. So generally, in all these cases that I've ever been involved in, when you get a subcontractor whose employee is injured, the general contractor generally knows that there was an injury. And
You said that there was no statutory authority to implead the general. What statutory authority is there for you to seek recovery against?
44-503 and 44-532A.
Well, 532A just says employer. What do you look to in the statutes that tells you that employer means the general contractor?
44-503 says when you're using the term employer, you can substitute the word principal.
That's only in the context of a claim by the injured worker against the principal. The actual language, I mean, I think it's important to be precise here. 44-503 only says that you can substitute those terms where compensation is claimed by the injured worker against the principal. It doesn't say that you can interchange those terms when the fund is trying to recover.
Well, the statute says that when you're using the term employer, you can substitute the word principal.
Where does it say that? Anywhere other than 503?
No.
And isn't that really your statutory hurdle in this case?
Because 44-532A uses the term employer. So under 44-503, you can, since there was a general contractor, you can substitute the word principal for
Well,
employer.
I guess what I'm asking is,
44-532A.
what's your best argument for why the language in 503 that talks about substituting the principal for references to employer, what's your best argument that that is broader than just being cabined within a claim by the injured worker?
Well, the statute there is intended to hold the general contractor responsible for all his subs. And if you can't substitute principal in for 44-532A for the term employer and used in that case, then the workers' compensation fund is going to be responsible for paying the claims and having no recourse against the general contractor who has now violated 44-503 and is getting immunity.
Well, I think I probably agree with that statement, but this, I'll just circle back one last time to, this is why I was asking the questions about the holding in silicone, because it strikes me that the silicone holding starts from the proposition that, hey, the worker doesn't have to exhaust its remedies. And we're comfortable with that because the fund, we're going to say the fund can always go back against the principal. I'm not sure that this language of the statute supports that.
Well,
But I'm asking if that's wrong, do we need to follow the whole chain of reasoning back to the central holding of silicone, which is the injured worker does not have to exhaust remedies?
Under the way the statutes are written now, the injured worker does not have to exhaust his remedies against both the employer and the principal.
That's just a result of our holding, correct? There's no statute that says that, is there?
But the statute does say where compensation is claimed from or proceedings are taken against the principal in 44-503. And is this a proceeding or a compensation claimed? It doesn't say that the compensation has to be claimed from the injured worker, right?
Correct.
And this is the controlling statute, 44503, on subcontracting that should be applied, when we look at the Workers' Compensation Act as a whole. We look at it in peri material altogether, right?
Right. The other thing I would, call the court's attention to is the case of Durante versus DeBruce Grain, when they were dealing with 44504. And in that case, when you're dealing with employer, this court said you could substitute principal in that particular case also when you were dealing with the negligence of the employer. So
they made that connection in the Duarte case between 503 and 532A.
in Durante, they made the connection between 44503 and 44504, which is subparagraph D. When they were talking about employer in that case, they said you could substitute principal when you were dealing with a question as to the negligence of statutory or the employer, the general contractor, and the immediate employer.
What I'm suggesting is that that also is how it's extended to 532A, correct?
Correct. I guess I would sum this up by simply saying we believe the interpretation under the original Silicone case and the Court of Appeals' recent decision is correct. If the legislature had thought that this court's interpretation in Silicone and later in Durante was incorrect, they had the opportunity to amend the statutes. 30 years has gone by and they have chosen not to do so. So I think this court's rationale in those two cases is correct, and the fund should be able to go against the principal. I'm out of time with respect to my cross appeal. I will rely upon the brief that we filed on the request for attorney fees. Any other questions?
Thank you. Counselor, you reserve 3 minutes.
Thank you, and may it please the court again. Precision of language is what we're talking about, and the statutory language is sometimes obscure, and seemingly in workers' compensation, they don't get it right frequently. We can talk about the remedies and the doctrines for statutory employer or support from the Workers' Compensation Fund, but again, we look at the language. Justice Stegall, I don't think that a decision here impacts the holding from the Silicone Distributing case. The holding there was simply, you don't have to exhaust your remedies. That's what 44503 says. You can take your choice. You can make a claim against a subcontractor. You can make a claim against the principal.
Well, it seems to me like, let me just float this, that you're trying to win the whole enchilada here, which I understand. But it strikes me that possibly the statutes only give you half the enchilada, which is that perhaps if we reject the what you call dicta in Silicone, it undermines the central holding of Silicone. That in fact what the legislature intended, the legislature did intend to hold principals liable for this kind of a loss, but it also intended to give principals their day in court. And it seems to me like that's what your client loses under Silicone, is you lose the ability to contest the award, because the fund just pays it out knowing that they can turn around and stick you with the bill. Whereas if the worker had to exhaust remedies under 503, at least you would get to have your day in court.
That may be true, and again, I think 503 gives alternative remedies, and to be clear, with Mr. Nodgaard stating he was trying to implead Trademark, there's no procedure for that. There's no procedure for Trademark to come into the workers' compensation claim. So again, as we're looking at the language of 44, 532, and 503, 503 deals with the workers' compensation claim in progress. 44, 532 just couldn't be more clear in our view. in this court, and Mr. Naugard says, well, the legislature hadn't changed it in 30 years, so it must be right. No, this court has changed the case law in Kansas in the past 10 years or 15 years from what it was previously. In a series of cases that start with Casco, this court overruled case law that existed for 70 years. In Bergstrom in 2009, same thing. Hosley had to deal with 44501H. In 2015, even in this past year, this court has dealt with Johnson versus U.S. Foods. Justice Stiegel, you looked at the language of the statute to determine that competent medical evidence was more important than choosing a 4th edition or a 6th edition. In Hawkins versus Southwest, despite that we all know that judgments aren't fungible, we have a case where somebody in a jury trial that received 0 imports that comparative fault to a prior judgment based on the language of the statutes. And Justice Biles, you commented that the obtuse language in the statute dictated that result. Well, this may be obtuse language also, but it dictates the result here. My client, Trademark, was not insolvent. It was fully insured, and it was not the employer of Mr. Medina.
But counsel, you can't have it both ways. That it's obtuse language and that it's difficult to interpret, and also that it's absolutely plain language.
Well, I'm not sure I understand, though. Again, I think that that is what's happened in workers' compensation, that there is plain language that this court has then applied. And again, that's my point in Casco, Bergstrom, Hosley. You've gone back and looked at other decisions using the same language and reached completely different results.
Right. Bergstrom did absolutely address the importance of first looking at whether or not the plain language tells us the answer. But Bergstrom presumed requirement of good faith that wasn't anywhere in the language. And they said, wait a minute, we can't do that. In this case, the language itself must be interpreted to be plain. And we have prior case law that tells us the word employer is not plain. It is ambiguous, don't we?
Well, the word employer is defined in the Workers' Compensation Act. I think that's a starting point. And again, our focus here is 44.532A. And if you read Sections A and Sections B together, whether you apply the dicta from Silicone or not, you still can't get to the same result that there should be liability against Trademark. It just doesn't fit within that statutory construction.
Well, but the Duarte case that opposing counsel mentioned also said you can read it reasonably such that you can substitute one employer for another employer within the context of the same statute, the same section.
And
Would we have to overrule the Duarte case then?
44.504 is a completely different statute than 44.532A. There, the substitution of employer for, or principal for employer, maybe that works better. It's hard to read through 44.532A and figure out how that's going to work. For example, if you insert the word principal for employer and then apply that to the statutory language that we have a principal that has no insurance or insufficient self-insurance bond, and a principal is financially unable to pay compensation, and a principal that you can't locate, then the commissioner has a cause of action against the principal. Again, those things just don't track well. And again, our point here is this case, like the others I've identified, this court should evaluate the language, and it reaches a result which is still fair, but it may change prior case law. And again, that's what this court has done before and what we believe should happen here.
I guess what I'm asking you, though, that I'm confused about, because in the Duarte case, they were making that same argument. They said it's nonsensical if you simply substitute one for the other. And our court said, as a general rule, statutes are construed to avoid unreasonable results. because the principal and the immediate employer are dual employers under 44503A, there is no inconsistency in substituting either principal or the contractor for the term employer in 44504D as appropriate. So why doesn't that also apply in 44532?
Well, and again, this goes back to 532A requires that the employer or principal have no insurance, have insufficient insurance bond, be financially unable to pay. It's a different construction of the language. It doesn't work. 503 and 504, maybe they're interchangeable there. It doesn't work well here. I'll note in Silicone, it's odd to me that the workers' compensation fund in Silicone was exactly the same argument we're making here. The fund argues that employer in 44532A, A and B must refer to the same entity. If employer in KSA 44532AA does not refer to a principal, then employer in 44532AB cannot refer to a principal. Again, just an irony that here 30 years later, the argument the fund tried to assert in getting the exhaustion of remedies argument is making the same argument we're making here.
Okay,
Statutory construction.
let me follow up real quickly on
Okay.
that. I know you're out of time.
Oh,
But
happy to be here.
It sounds like you would concede that under 44-503, you are an employer. Under that limited statute, 44-503, you're an employer.
Yes,
And you have insurance, right?
got insurance.
So given that, how can the injured worker ever proceed under 532A? Because there is an employer, and that employer does have insurance.
I think, Justice Stegall, this goes back to language in 44503, and this is subsection C. Nothing in this section shall be construed as preventing a worker from recovering compensation from the contractor instead of the principal. So in other words, it's in their choice.
My point is that the injured worker under 532A, as I read it, but correct me if I'm wrong, cannot proceed against the fund. There's a condition precedent, and the condition precedent to proceeding against the fund is that there's no employer with insurance.
I think that's true.
But in this case, there is an employer with insurance,
Well-
and that's your client.
No, and see, that's where I disagree.
I thought you just conceded that you were an employer.
Within 44503, if
Okay.
we're following the language of 44503A, where their compensation is claimed or proceedings are taken against the principal, then that application, where the references are exchanged.
You just want to draw a bright line between the two statutes and keep them separate.
Well, only when it applies to the claim against the contractor instead of the principal, because that's what the plain language of those statutes leads to.
Okay, thank you. Appreciate it.
Thank you. If there are no other questions, thank you very much.
Thank you to both counsel for your arguments today. The court will take this appeal under advisement.